Hello everyone, like promised, I'm coming up with a high-yielding video series for understanding complicated topics for Prelims 2023 examination. The conceptual understanding will be very crucial for elimination of options and arriving at the right answer. So the first topic that I am selecting for this video series is the Supreme Court verdict on Prevention of Money Laundering Act's provisions. That case is famously called the Vijay Madanlal case. In this video, we'll try to understand what is Enforcement Directorate, what are the provisions that govern the functioning of Enforcement Directorate, what is the controversy that is surrounding around the functioning of Enforcement Directorate, and how it is important for our prelims examination. And of course, in the end, we'll be talking about the provisions which are important for prelims examination. The central issue that this particular law of PMLA is the issue of money laundering. Now, what exactly is this money laundering? Let's say, for example, an activity is done and that activity is considered to be illegal. If someone gets that money illegally, if you are trying to conceal or disguise the identity of that illegal proceeds and you want to paint a picture that it is actually originating from a legitimate source, that you are converting that black money into white money, that process is called money laundering. And according to IMF, 2 to 5% of the global GDP is involved in this money laundering activities. Now, when we're trying to paint a picture that this dirty money is finding its place into the legitimate financial system as good money, you're acting against the sovereignty of a country. That is the main problem here. And to solve that problem, we have a law called the Prevention of Money Laundering Act 2002. Now, since it is considered to be an act against the sovereignty of a country, it is a criminal law. And that is why, if you take a look at the case we are discussing, Vijay Madanlal Chaudhary versus Union of India, this word, Union of India, signifies that it is against society and against the sovereignty of a country, and that's why it is a criminal law. So there is a convention called the Vienna Convention to prevent money laundering, and India is a signatory to this convention. And to give power to that convention, India brought this framework, legislative framework, under the PMLA 2002. As per the provisions of this, remember this is going to be very important, this law gives blanket powers to an organization called Enforcement Directorate to seize, investigate, search assets of any accused therein. So here is where you have to understand. This law gives separate provisions and separate rules and regulations to deal with this case because it is an act against the sovereignty. Now, you have to remember that there is something called rule of law. As per right to equality and under Article 14, we have something called rule of law. And to give effect to this rule of law, we have certain established procedures under law. That established procedure is codified under CRPC or the Criminal Procedure Code. This is where the problem begins. To begin with, this organization called the Enforcement Directorate, should it function as per the provisions, the blanket provisions that it got under the PMLA, or should it stick to the procedures established under CRPC? This is the main bone of contention or the controversy here. Why is it a controversy? For example, Section 45 of PMLA makes it very difficult for a person who is accused to get a bail under this act. But that is not the case in CRPC. I'm not dwelling into the details of CRPC because that is not relevant here. I'm just giving you an example. So there are many procedural issues like this, and these issues were supposed to be discussed in the Supreme Court. And this case has exactly clarified on those provisions. The fundamental issue here is, according to the 7th schedule of our Constitution, law and order is a state subject. That means police should be the one who should start this investigation procedure in the criminal justice system. So let's say, for example, if there is a complaint, then based on that complaint, the police would first register an FIR or the first information report. Then there will be an investigation from the police. Based on the facts and evidences gathered in that investigation, there will be a charge sheet, which is a document which is presented to the court, based on which judgment would be given by the court. This is the standard workflow. Therefore, by definition, law and order is supposed to begin with the state, that is at the police department level. Now, what is the scope of Enforcement Directorate and other national organizations, this is a question that one should ask. So for this purpose, based on an initial complaint or an FIR, Enforcement Directorate is supposed to come up with another document. That document is the initial point where ED investigation starts. The document is called ECIR, or the Enforcement Case Information Report. This cannot be filed without an FIR. Now, every person who is arrested or undergoing a judicial process has certain rights. Let's say, for example, if a person is about to be arrested, he's entitled to get that FIR copy because he wants to know the grounds on which he or she is arrested. But as per the provisions of ED, that power is vaguely described in the PMLA. The Supreme Court verdict clarified the powers and reiterated that Enforcement Directorate is distinct from police in the fact that there is some section called the Section 50 of the PMLA. Enforcement Directorate need not supply a copy of this ECIR with an arrested person. Secondly, the court also clarified that unlike in the case of police, if in the process of investigation, Enforcement Directorate records certain statements, those can be admitted in court as evidence. The next point that we should discuss is the aspect of bail. Now, as per Indian Constitution, every accused is entitled to apply for bail as per Article 20, 21 and 22. You know what these provisions are, so please revise them. But what exactly is a bail? It's a legal agreement. Legal agreement between the accused and the court, in which the accused pays a sum of money as an assurance that he or she will appear in the court whenever asked. The accused can be released temporarily on a payment of bail. There is one category of bail called the anticipatory bail, wherein the accused takes the bail even before the arrest in anticipation of an arrest. So basically, court denied giving this anticipatory bail to the accused in these PMLA cases. The rationale given by the court is that it is possible that the accused can obstruct the case proceedings. However, the court said under trails could seek bail under the CRPC section 436A if they had already spent one half of the term of punishment in jail for the offense prescribed in law. Next issue is the retrospective application of the law. For example, in PMLA, there is one schedule or a list of offenses which is defined as per law. Now, proceeds of crime as per money laundering definition according to this act means any property that is derived from an offense which is defined in the schedule offense. Now, the problem is this list can be very narrow at the point of legislating it, and as time progressed, many amendments were taken up, and more and more number of offenses were added to this list. When more and more number of offenses were added to this, it gave a scope for ED to apply the law retrospectively. For example, an offense X, which is not defined in the scheduled offenses, was added later through a legislative route, and then Enforcement Directorate applied that law on a person accused of getting a property through this illegal activity. But the petitioners argued that according to Article 20 Clause 1, this kind of retrospective reading of the law is violative of the fundamental right. What did the court say on this issue? Supreme Court actually upheld what Enforcement Directorate was doing, saying that the offense of money laundering is a continuous one. I mean, it's not like once you acquire that property, you stop enjoying it only for that moment. It's not a momentary thing. You continuously enjoy that proceeds of crime. So, it can be acted upon independent of when the scheduled offense was committed. This means holding that property which one derives from an offense which may not have been a scheduled offense at the time of the commission of the offense will be defined as money laundering. This is the most important provision that you have to understand, retrospective law. So it is not violative of fundamental rights, because money laundering according to Supreme Court is as serious as terrorism, because the money that is ill obtained can be used for anti-national activities like terrorism also, and therefore it is justified that this sort of retrospective provision of law is upheld by the Supreme Court. So these are some of the important provisions that you need to know about Enforcement Directorate. I hope you read the provisions of Enforcement Directorate, which laws are handled by Enforcement Directorate. All this basic information can be obtained through the website of Enforcement Directorate itself. This procedural aspects are a bit complex, and therefore I created this video. I hope you enjoyed this. If you like it, please like the video and share it with your friends. That's it for now. Thank you. I'll be coming up with more videos.